I seek Lordship's indulgence in making a mention on behalf of the counsel for the appellant in item 8, part 2, hearing list. On behalf of Mr. Lalfak Oma. Yes, Lordship.
Lordship, I'm appearing on behalf of the respondent, Lordship.
Okay. Any objection?
Lordship, the only objection here is that, Lordship, it's limited, the liability has been admitted. Now the only question is the quantum, Lordship. So if the matter can come up as a fixed matter.
Lordship, if possible after vacation, as requested by the counsel for the appellant.
No, we have no objection. No objection, Your Lordship.
Okay. President list the matter on suggested date after reopening 13, 14, 15th of July.
15th of July, Lordship.
15th. Okay.
Also, Lordship, item number 12 of the hearing list.
Daily list.
Hearing list, part 2 hearing list. For the same counsel, my lord, on behalf of Mr. Lalfak Oma.
Okay. Chair Morton.
Yes.
You obtain consent from the other side.
Yes, Lordship.
Okay. Okay.
Obliged.
Daily list for admission, item 1.
For this matter, the senior counsel has some personal difficulties. So, if this matter may come up on the 29th June.
Okay. You are appearing on behalf of?
Mr. Adesh Yanshima, senior counsel.
Respondents 1 to 3.
Respondent 1 to 3.
Okay. Ms. Sunsul, learned counsel, appearing on behalf of the learned conducting counsel for the respondent number 1 to 3. With consent from the other side, press for listing the matter on 29th of
June.
June. 29th of June. Okay. Fair allowed. Let's establish the
Obliged.
matter on 29th of June.
Deeply obliged.
Item numbers 2, 3, and 4.
Your Lordship, I appear on behalf of my senior CTC, Ms. Zara Changui, for respondent 4, and we will not be filing the affidavit in opposition.
Yes, Your Lordship, I represent respondent number 5, number 1 and 2 in item number 3. And I'm seeking another 3 weeks time to file my affidavit.
Prayer in item number 2, I think the respondent number 1 and 2.
Respondent 1 and 2. Any objection, madam?
Lordship, no objection.
No objection.
And moreover,
Heard
Lordship, you have to
Mr.
file
Wilson.
a rejoinder affidavit.
Learned counsel for the petitioner and madam for respondent number 2.
1 and 2.
No, in item number 2.
For the respondent number 1 and 2.
1 and 2. And anybody? Okay. In item number 2, you are not there in item number 2. Okay. The learned counsel for the respondent number 1 and 2 submits in item number 2 submits that she may be granted 3 weeks time to file counter affidavit. Fair allowed. Recessal is the matter. Should we fix it that?
Lordship, it may be listed after 2 weeks, and also that Lordship, if I may be
After
allowed to
vacation?
file, yes,
After vacation?
after vacation,
After
after
vacation.
to file a rejoinder affidavit filed by the respondent number 5 and 6.
The learned counsel for the petitioner submits that she may be allowed to file a rejoinder affidavit. They are allowed. In item number 3, you are for respondent number
1 and 2.
1 and 2, and she prays for granting her 3 weeks time
3 weeks time.
to file counter affidavit. They are allowed. And you are in item number?
It's 4,000.
Your Lordship, item 234, in each of them, I am representing respondent for each.
Or is?
Yes, Your Lordship.
Okay.
Lordship, they have already submitted that they will not be filing an affidavit in opposition in all the three cases, item number 2, 3, and 4, the central government.
Okay. Who is appearing for central government? You.
Your Lordship, I appear on behalf of my senior CGC, which is Ms. Zainam Sangpui.
They are respondent number 4.
So
That
you
is
are not
respondent number
interested to file your counter affidavit here?
Yes, Your Lordship.
Not interested.
Yes, Your Lordship.
Okay. Okay. And you, Mr. Who in the item number? Item number 3, for respondent number 5 and 6. You have already filed your affidavit. Okay. So you are sure that the CCC will not file counter affidavit in this matter?
Yes, Your Lordship. If ever the instruction have not been delivered from the department as of now.
You have not received the instruction?
Yes, Your Lordship.
Okay. Okay. The learned counsel appearing for the CGC submits that requested instruction has not yet been received in respect of filing of the counter affidavit. Okay. Accordingly, it is provided that he shall receive necessary instruction in respect of filing of counter affidavit before next date. List the matter after vacation.
Yeah, Lordship, in this matter also, if I can be allowed to file a rejoinder affidavit.
Okay. The learned counsel for the petitioner submits that she may be allowed to file counter affidavit in, rejoinder affidavit in this matter. They are allowed.
Item 5.
Lordship, I'm appearing on behalf of my senior for the respondent number 6, my lord, the MPSC, and we have filed our affidavit, Lordship.
So, my lord, if we may be given another 3 weeks' time to file a rejoinder affidavit to all the affidavit in oppositions.
Okay. Heard, Miss?
Latang Hui.
Learned counsel for the petitioner. And Madam?
Definitely Shwaitlongi, my lord, on behalf of my senior, Jessie Danunsanga.
Senior?
Jessie Danunsanga, my lord, for respondent number 6.
Respondent number 6.
Yes, my lord.
And you have filed your affidavit?
Yes, my lord.
Counter. She submits that she has filed a counter affidavit in this matter. The learned counsel for the
And Your Lordship, I'm representing the state respondent 1 to 5.
1 to 5. You have filed your affidavit?
Yes, we have filed our
Okay. The learned counsel for the petitioner submits that she may be allowed, she may be granted some time to file a rejoinder affidavit.
Yes, my lord.
Accordingly, they are allowed. Accordingly, it is provided that recessal is the matter. When?
After 3 weeks, my lord.
After 3 weeks. Recessal is the matter after 3 weeks.
Item 6.
Yes, Your Lordship. Here I'm representing the respondent number 1 to 6, and I'm seeking another 3 weeks' time to file my affidavit, Your Lordship.
Okay. Heard, Miss?
Biraram Nemi.
Learned counsel for the petitioner. And Madam so learned counsel for the respondent number 1 to
1 to 6.
1 to 6. And she prays for granting her 3 weeks time to file counter affidavit. They are allowed. Recessal is the matter after 3 weeks.
My lord, if the date may be fixed. If the date may be fixed.
Date.
Yes.
Okay. Recessal is the matter.
16th of July.
Oblige.
Obliged.
Item 7. Item 7.
None appears for the petitioner on call. List the matter.
Yes, sir. Item number 7. I'm appearing for the petitioner.
Petitioner.
As per the, yes, my lord. As per the last order, my lord, time was given to the council for the respondent number 1 to file the affidavit in opposition.
Behalf of the respondent number 1. However, we have not yet received any instructions as of now, and the respondent number 2 and 3 is not yet represented. 2 and 3.
Okay. Heard Mr. Sakma, learned counsel for the petitioner, and Madam for the respondent number 1.
The respondent number 2, 3, and 4 is not yet represented.
Whether notice was served upon them?
Yes, my lord.
Respondent number 2, 3, and 4 remain unrepresented today. The learned counsel for the respondent number 1 submits that she has not received any instruction till date. So when can it be fixed?
If your lordship can grant me another 2 weeks' time to get the instructions.
However, learned counsel for the respondent number 1 submits that she may be granted 2 weeks' time to receive the instruction. Pair allowed, rest is the matter. After vacation?
Yes, your lordship.
After vacation. Immediately after reopening of vacation.
Thanks, my lord.
Item 8.
Yes, your lordship, if this matter may be passed over for the time being.
Time being?
Yes, your lordship.
Why?
The learned counsel who is handling this case, now she is conducting hearing in court number 2. So if this matter
Okay,
may
after
be,
some time.
yes.
Item 9.
Your Lordship, in this matter, respondent number 5 and 6 have filed their affidavit of opposition. And in the last court date, respondent number 3 has been newly represented. So 1, 2, 3, 4 has not filed.
Your Lordship, I am appearing on behalf of Mr. Jonathan Nalrintonga for the respondent number 3. So he has some personal difficulty today. My Lord, if 2 weeks' time may be granted for filing counter affidavit, my Lord.
Your lordship,
Okay.
I'm appearing on behalf of respondent number 1 and 2, and that similar prayer, your lordship.
Respondent number
1
1
and 2.
and
1 and 2, your lordship.
1 and 2.
Lordship, I appear on behalf of my senior CGC for respondent 4 with this similar prayer.
Heard Mr.
Jonathan L. Samuel.
learned counsel for the petitioner, and also heard
For 5 and 6, Mr. Samuel, ma'am.
learned counsel for the respondent number 5 and 6.
Yes, ma'am.
5 and 6, and you for respondent number
3.
respondent number 3, and madam for 1 and 2. 1 and 2, and you for respondent number
4.
4. Respondent number 4. The learned counsel for the respondent number 1 and 2 and 1, 2 and 3 rise for granting 3 weeks time
My Lord.
to file counter affidavit. To file counter affidavit. The pair having not been opposed by the petitioner stands allowed. Rest is the matter after 3 weeks.
Deeply obliged.
Borders, item 10 and 11.
Lordship, I'm for respondent number 1. If I may give him further time to file an objection.
Okay.
My lords, Here, my lord, the difficulty is that, my lord, an execution petition is pending before the learned trial court against me, which the private respondent have filed. So if they are taking more time, my lord,
I will able to file within a week, my lord.
next week, my lord.
No problem, my lord.
Okay, heard Mr. So-and-so, learned counsel for the applicant, and madam for the respondent number
1.
1. Q for respondent number 224. 224. The learned counsel, you want to file objection? Okay. Learned counsel for the opposite party number 1 submits that she may be granted 1 week time to file objection. Pair allowed, recess the matter on next week,
Next week, my lord.
Yes.
25th, my lord.
25th.
Or we can take it up on the 29th also, my lord. 29th also.
Okay, 29.
Oblige.
Item 12.
Yes, Your Lordship, this is a state appeal, and I believe that the respondent number 1 and 2 is going to be represented.
Yes, Your Lordship, I received instructions to represent respondent numbers 1 and 2, and I will be finding my power during the course of the day.
Okay. This I is for
Condonation of delay. The delay is
heard
262
Madam
days.
so learned counsel for the applicant and Madam for respondent or opposite party number
1 and 2.
1 and 2. 1 and 2. The learned counsel for the opposite party number 1 and 2 submits that she will be filing her power during the course of the day. Then you want to file objection?
No, Your Lordship.
No.
Yes.
Then can we condone the delay today?
Yes.
Yes, Your Lordship.
You have no objection?
Yes, Your Lordship.
How many days delay of?
262 days.
In which paragraph of your application you have explained the delay?
In the IA application starting from para number 2.
This interlocutory application is preferred by the applicant for condonation of delay of 262 days in filing connected regular first appeal against the judgment in order dated 19/7/2024 passed by the learned civil judge junior division number 4 Aizal in civil suit number 99 of 2022. The learned counsel for the applicant submits that though the judgment and order was passed on 19/7/2024, yet due to some unavoidable circumstances which was required to be followed by the applicant as usual course of government proceeding, such as obtaining opinion, the department and also from the office of the Advocate General and also from the Government Advocate Gauhati High Court Aizal bench. The appeal could not be filed in time and the delay is not intentional, rather it is circumstantial. And under such circumstances, he is contended to condemn the delay of 262 days in preparing the connected appeal. The learned counsel for the opposite party number 1 and 2 submits that she has no objection. But having heard the submission of learned counsel for both the parties, this court has carefully gone through the application and the explanation put forwarded in the said application. And it appears that the delay of 262 days in preparing the connected appeal has sufficiently been explained from paragraph number 2A to 2O. And accordingly, the same stands condemned. In terms of above, this IA stands disposed of. In view of the order passed in the IA, now the registry will register the regular first appeal and list the same before the court as soon as practicable. RFA has already been numbered.
Yes, Your Lordship.
List the matter after a week.
Item 13.
May please your lordship. This bail petition has been filed under section 482 of the BNSS read with section 37 of the NDNPS Act. Well, it's the brief facts of the case is that on 27th of January 2026, the two petitioners, along with Mr. Kaimul Hussein, were arrested in connection with the seizure of 597 grams of suspected heroin. And then they were booked in Ngopa PS case number 1 of 2026 under section 21C, 25 and 29 of the NDNPS Act, my lords. My lords, the grounds of arrest, this is the prayer. The petitioners prayed for release of due to violation of the Article 22 of the Constitution of India, due to the grounds of arrest were not informed, my lords. In this regard, your lordship, if I may kindly take your lordship to page number 15 of the petition, which is notice under section 47. Page 17, my lords. Page 15 and 16. My lords, in notice under section 47, my lords, the section for which they were arrested were informed, but the grounds of arrest, the basic facts for which they were arrested, were not informed at all, my lords. And my lords, regarding section 48, my lords, the no notice under section 48 was issued to the family or friends of the petitioners, my lords. And my lords,
in page number 15 and 16, it has been clearly stated that they are arrested for commission of the offense under section 21C 25 and 29 of the NDPS Act.
Yes, my lords, exactly. But my lords, the grounds of arrest. So the reason for the arrest of Abar Hussain, the petitioner number 1, is the contraband article was recovered from the spare tire from his vehicle. So that is the reason. So with regard to the petitioner number 2, Fayaz Ahmed, so the allegation against him is that he was he's driving in another vehicle, and then the allegation against him is that he is escorting the involved vehicle. So the basic facts for which he was arrested, the reason for which he was arrested has to be informed, my lords. So he is not a lawyer.
Section 29 is there.
But my lords, the reason, the basic fact has to be informed, my lords. So if you come to page number 17, that is Kaimul Hussain, that the notice under section 47 were the same. My lords, if I may kindly take a lordship to from page 50 to page 53. So Mr. Kaimul Hussain was released by a coordinate bench of this court due to violation of section 47 and 48, my lords. And the relevant portion paragraph is from paragraph 7, my lords, page 52.
Okay, let the record come, we will see. At what stage the case is pending?
My lords, charge sheet is not filed till date.
Charge sheet has not been filed.
Yes, my lords.
Then let the CD come, we will see.
CD has been annexed, my lords, which is at page.
Your Lordship, this is the first time it is listed. And if notice may be issued regarding this, and the CD may be called.
CD is at page 32, my lords.
Your Lordship, we cannot rely on only what the applicant has produced. We have to call for the original CD, scanned copy of original CD.
Page number?
32, my lords.
No, this is not the CD. Let the CD come, we will see. Heard, Mr.
Yes, my lord.
Learned counsel for the petitioner. And also heard Madam Po, you are appearing in additional PP, learned additional PP for the state respondent. This application under section 483 of the BNSS 2023, reduced section 37 of the NDPS Act is preferred by the applicant, preferred by the accused for granting them bail in Nagopa PS case number 1 of 2026. The learned counsel for the petitioner submits that the accused persons were arrested on
27 January 2026.
27/1/2026, and since then they are languishing in jail hazard, and that while causing arrest of the accused persons, the arresting authority has not informed the ground of arrest, and on such ground, a coordinate bench of this court has enlarged one co-accused, namely Kaimul Hussain Barbhuya, on bail by order dated 5/6/2026 in BA number 36 of 2026. And the learned counsel for the petitioners further submits that the present petitioners are also similarly situated with said Kaimul Hussain Borgoya, and as a similar benefit may be extended to them also. However, learned additional PP submits that perusal of the case diary will be required in dealing with this bail application, and therefore she has contended to call for the scanned copy of the original case diary. Accordingly, it is provided that you produce the case diary.
Yes, sir.
Accordingly, it is provided that the learned additional PP shall produce the scanned copy of the case diary before this court on suggested date
29 June.
29th of June.
Yes, Your Lordship.
Yes, any objection?
My lords,
29th of June?
my lords, it can be sent to WhatsApp also, my lords. So there, since the case is only a scan copy, my lords. So if it may be taken up again on next week, my lords.
Your Lordship, this case is pertaining to Ngopa, and this is not in ISO. So I have to contact the case IO and they have to send. So it might take time.
No, scan copy, you can get it through email.
I understand that, Your Lordship, but however, even in 1 or 2 days, they cannot complete because they are quite busy as well.
Okay, let it be on 29th. Yes, next attempt.
Deeply obliged.
Item 40.
May it please your lordship.
Yes.
Lordship, this IA is with regards to a condemnation of delay of 10 days, lordship.
Okay.
Lordship, I have the authority to represent the sole respondent, my lords. So I was instructed last night, only last night, to appear on her behalf. So, my lords, I will submit my power during the next week, my lords. So the petitioner and the respondents are living in a far-flung area, which is the autonomous district council area, my lords.
Also, lordship, there is one urgent matter with regards to this, lordship. During the filing of this RFA, lordship, the respondent herein had filed an execution before the district council court. And now the district council court had passed an order on 11th of June 2026, lordship, wherein through the judgment and order, lordship, if I may.
You say delay is only of 10 days.
My lords, I have not received a copy of the petition, so.
Okay. Let us list the matter in the next week.
Lordship, I just want to mention one thing is that there is an urgency because through this order of 11th June, lordship, if I may go to lordship, whereas the execution petition was filed before this Honorable District Council Court on 21st of April 2024 through her legal counsels by Srimati Badi Chakma's wife of such and such, praying for the execution of the judgment and order dated 15th of December 2025 of this Honorable District Council Court. And whereas the learned counsel for the petitioner prayed for passing the necessary order of the payment of rupees 5 lakhs only of the decree holder petitioner without further delay. And whereas the counsel for the respondent prayed for keeping the execution petition in abeyance and stay all coercive steps against the respondent during the pendency of regular first appeal before the Honorable Gauhati High Court Isol bench. He further prayed for not issuing any warrant, attachment or arrest and any other coercive process under Rules 46 subsection 4 and Rule 49 subsection 1 and 3 of Poilakir Administration of Justice Rules 1954. Now, therefore, in pursuance of the judgment and order dated 15th of December 2025 of this Honorable District Council Court, CADC, and in connection with this case, it is hereby ordered by this Honorable Court that a sum of rupees 30,000 only per month for 16 months and 20,000 only for on the 17th month to be deducted from the salary of Sri Onishmoy, ex-MDC, such and such, with effect from the month of June salary 2026 onward, and the same deducted amount be deposited to the SBI account number such and such of Srimati Badi Chakma. Now, lordship, if this order is not stayed at this stage, lordship, the appellant would suffer irreparable loss, lordship. While the matter is supposed to be adjudicated right now at this stage, lordship, if this order is not stayed, Lordship, then now, Lordship, the only one who will suffer is the appellant, Lordship. And the respondent is very well aware of the appeal which has been filed before this Honorable Court, Lordship. And notice has been issued as per the order dated.
Lordship, the matter may be come up again on the first week of July, my Lordship.
No, Lordship, during the pendency of the order is not stayed, Lordship. The order has already been passed. Now, at any moment, the amount may be deducted from his salary, Lordship.
No, the amount will be deducted from your salary.
Yes, Lordship.
So you will get the salary at the end of the month.
I understand, Lordship, yes.
So we'll list the matter in the next week.
All right.
Let it be on Tuesday. In the meantime, you file power and you obtain instruction.
My Lordship, there is some difficulty. So,
Why?
because the respondent, she is living in a far-flung area in a village, my
Maybe.
Lordship. So the power of Wakalat Nama has to be sent to a sumo service, my Lordship. So we have to send it, and they have to send it back again.
Sumo service is
that's-
available on each and every day.
Not,
Yes,
not,
Lordship,
not,
it's
my,
available,
not each and every day, my Lordship. So they have come.
You get it through email.
My Lordship, power of Wakalat Nama cannot be sent to email. So my Lordship, original has to be filed before this honorable court, my Lordship.
Okay. Then let it be on Thursday.
My Lordship.
Thursday.
Lordship, if I can get maybe serve a copy of the.
Copy. Yes,
No
you
issues,
will serve a
Lordship, we
copy.
will provide it, Lordship.
Heard, Mr.
Samuel Patswell.
Learned counsel for the petition applicant and Mr.
Yes, my Lordship.
for the respondent, opposite party. The learned counsel for the opposite party submits that he will file his power in the next week. However, he submits that he has not been provided with a copy of the application, interlocutory application. Learned counsel for the applicant undertakes to furnish a copy of the same to the learned counsel for the opposite party during the course of the day. Rest shall list the matter on Thursday
Deeply obliged.
as fixed matter.
Item numbers 15 and 16.
For the
I is
applicant.
for impleadment.
Yes, my lord.
Okay. Madam, any objection?
No objection, my lord.
No objection. Heard Miss,
Bilal Ramnemi.
learned counsel for the applicant, and also heard Miss.
Ms.
You are
Lal-
appearing in
Yes, Your Lordship. I am appearing for respondent number 3, 4, and 7.
3, 4, and 5, and Madam for
I'm for respondent number 2.
respondent number 3.
2,
Yes.
2, my lord.
This application under Order 1, Rule 10, Section 2 of the Code of Civil Procedure is prepared by the applicant for impleadment of Dr. Krasnendra Singh, the present incumbent of the present chief engineer, Border Road Task Force, BRTF project post grief, care of 99 APO as respondent number 8 in the contempt case civil number 18 of 2025. The learned counsel for the applicant submits that during the pendency of the contempt case number 18 of 2025, what happened to earlier incumbent?
He has been transferred out from his
That
post.
the earlier incumbent was transferred, and in his place, uh, in his place, Dr. Krasnendra Singh assumed the charge and charge of Chief Engineer, Border Road Task Force, BRTF, project post brief, and as such, he is required to be impleaded as respondent number 8 in contempt case number 18 of 2025. The learned counsel for the opposite party submits that they have no objection. Accordingly, taking note of the submission of learned counsel for both the parties, and also considering the facts and circumstances on the record, this interlocutory application stands allowed. Dr. Krasnendra Singh, the present incumbent, the present chief engineer of Border Road Task Force BRTF project was be impleaded as respondent number 8 in contempt case number 18 of 2025. In view of the order passed in the interlocutory application, the petitioner in contempt case number so and so shall file amended cause title within a period of 1 week from today.
Item 8 for admission.
Obliged.
Lordship.
Okay.
Sorry, Your Lordship, I wasn't late.
Okay.
Your Lordship, on verification of the service of the notice, it has been found that there is a return of notice that the respondents number 6 and 7 have received. Seven and 8. 6 and 7, Your Lordship.
Yes.
So as on today, Your Lordship, we have pressed for hearing of the interim prayer. Your Lordship, this matter pertains to the engagement of the petitioners as part-time assistant professors in the Bachelor of Computer Application Department in government colleges, Scholarship College and Champai College. Their engagement have been terminated with effect from 28 February 2026. Your Lordship, the impugn orders.
So
Impugn
your interim pair is to
interim prayer is for allowing the petitioners to continue as part-time assistant professors in their respective colleges, or to suspend the operation of the impugn office order that will come to the same effect. Lordship,
but
the
you
petitioner's
see,
prayer.
the office impugn order was passed on 12/3/2026. But you have approached this court by filing the writ petition on 19th of May 2026.
Prior to this, Your Lordship, I had approached this honorable court. I have annexed the copy of the order by which I was allowed to withdraw
Okay.
with liberty.
When,
At
when
page
did you
135.
when did you approach this court first?
It was in the month of February, after receipt of this 12/3/2026, no, not 12/3, 9/2/2026 order, Your Lordship.
No, impugn order is dated 12/3/2026. How can you approach in the month of February then?
No, Your Lordship, 12/3 is the subsequent appointment after termination of the engagement of the petitioners.
Okay.
12/3 is another appointment or engagement on ad hoc basis. So what I have stated here is that though the petitioners have been said to be without the necessary qualification, and their engagement has been terminated,
And by this order of 12/3/2026, the respondents, the private respondents number 6 and 7 have been appointed, though they were not eligible as per the version of the government. They did not have the required qualification. So, in a way, they have been replaced by another ad hoc.
Whether affidavit in opposition has been filed here?
No affidavit has been filed in spite of the sufficient chance given to them.
Yes, madam, you are not interested to file affidavit in opposition?
Your Lordship, this was moved recently only, Your Lordship. Your Lordship, except for respondent number 2 herein, the petitioner number 2 herein, the petitioner number, the other petitioners have already approached this honorable court, as the respected senior counsel have submitted, by filing the WPC 16 of 2026. Now, the respected senior counsel have annexed only the portion wherein they have sought the time for withdrawal for the matter with liberty. But Your Lordship, the same issue was heard in details in the IA for stay of the matter, and this was, if I may submit, Your Lordship, the order dated 3/3 of 2026.
So this person to the office order dated 12/3/2026, the new incumbents have assumed charge of the office?
Yes. Your Lordship, if the petitioners are not eligible for continuation of the engagement, why should the new incumbents, that is the respondents number 6 and 7, who do not have the required eligibility criteria, even as per their own standard, how can they be allowed to replace the petitioners? Your Lordship, there is the law has been well settled, Your Lordship. The law has been well settled. Yes. 2022. Your Lordship, if I take a Lordship to the law laid down by the apex court in the case of Manish Gupta versus Jan Bagidari, that is 2022-15 SCC. At page 540, the relevant portion is at page 543, para 13.
Yes.
Para 13. Lordship, from the lower portion of the para, starting with the word, it is a settled principle of law. As a Lordship put it, it is a settled principle of law that
Yes.
an ad hoc employee cannot be replaced by another ad hoc employee, and he can be replaced only by another candidate who is regularly appointed by following a regular procedure prescribed. Reliance in this respect can be placed on the judgment of this court in Ratanlal versus State, and this judgment was of 2022. Your Lordship, I am not able to convince myself as to why these two respondents should be allowed to replace the petitioners, except for favoritism or some other thing, not germane to the legal principle. And here, Your Lordship, the petitioners have been serving in the same capacity with effect from 2011. 2011.
No, another aspect is there. That is, if we grant the interim pair, then it would amounts to granting the final relief.
Yes, that could be one thing. But what we have sought for is not for continuation alone. We have sought for regularization. Regularization as assistant professor. Because, Your Lordship, in the year 2011, they were recruited as part-time assistant professor. And the eligibility criteria that was adopted was as per the...
They were selected by due selection process.
Yes, duly constituted selection committee, duly selected on the basis of their merit. And, Your Lordship, if I take Your Lordship to page 54, 54, this is the advertisement number 1 of 2011, dated 3/10/2011. Eligible candidates, Your Lordship, willing to apply should submit their application to so-and-so, and the educational qualification under clause 3. Educational qualification, master's degree in its field with 55% of marks at a master's level. Having knowledge of Mizo language up to middle school standard. That was the only criteria which was there in 2011 for the purpose of their selection for engagement as part-time lecturer. And why part-time? Because after being engaged as part-time lecturer for some time, depending upon the vacancy in the regular post, then they will be upgraded to contract employees. Then after serving in that capacity as a contract lecturer for about 7 years or 5 years, as the case may be, then they are eligible for regular appointment. So the process of selection in 2011 was very important. And the criteria that was adopted by the state government was this. And even if we take the eligibility criteria which has been prescribed by the UGC, the UGC does not make any requirement for having net in respect of the BCA department. Your Lordship, if I take Your Lordship to page 70, Annexure 14.
No, that's
page
all right.
70.
Their affidavit is not available before the court.
Yes, that is
We
true.
do not
That
know
is true.
their stand.
The
So,
stand
Madam,
is, the stand
can you
is,
file a short
Your Lordship,
affidavit?
yes, can file affidavit in a short period, like if I may be given at least 2 weeks' time, then
No,
we
no,
can
no, no,
have,
no 2 weeks.
Your Lordship,
not
this
2
was filed only in the month of May 2000.
Maybe, but there is urgency. Because you see, you have replaced a set of ad hoc employees by another set of ad hoc employees, which is not permissible.
Your Lordship, immediately after the vacation, because at least
No, no,
in
no,
1
no,
week
no,
we
no,
cannot, in 1 week we cannot file, Your Lordship. Because it has
You
to
file a
route through
short
the law and,
affidavit.
Your Lordship, it has to, with due respect, Your Lordship, it has to route through the law and judicial department. And whatever my learned friend have submitted, it has already been dealt with in the order that I have produced today, that the UGC did not provide the criteria so and so. Unless they challenge the
Your
order,
Lordship,
the order stands.
if
And
I'm
Your
allowed to,
Lordship, anyway,
if I'm allowed to submit, even in the earlier round of litigation, everything was prepared and then they're all equipped with all those materials. Now, because of sudden defect in the application, we had to withdraw this. And because of sudden developments, we had to file this writ petition again. And just because it was filed in sometime in the month of May, does not mean
Okay,
that.
okay. If you were not in a position to file the affidavit, then we will consider the interim period today.
Your Lordship, my humble prayer is that I may be given at least 2 weeks time. 2 weeks time. Only 2 weeks time. That is, if the matter can be fixed again on 2nd of July, so for final hearing. Before that, I will file my affidavit. With due
Lordship,
respect, it has to route from the concerned department. It has to route through the law and judicial department for vetting, and then it will go back to the department, and after that, it will reach me only. So it takes time, Your Lordship.
Lordship, the practice is that when we have an interim prayer, the matter cannot be considered except after giving notice. Now that notice has been given, it is not necessary that they should file their reply or in the form of affidavit in respect of the whole thing.
Your
But
Lordship,
once they
my
are
friend
I
is
mean,
not
they
scared
are
that we will give all
given
the
the
details in full.
opportunity of objecting it with all the materials they have, they can very well object it, and then the matter can be decided. The merit of the case will not be decided, but at this stage, for the purpose of deciding the interim prayer, a Lordship, affidavit may not be necessary.
No, that's all right. But since the granting of interim relief amounts to granting the
Not
final
entire,
relief in
not,
the
not,
petition.
not the final relief, Your Lordship. What I have sought for, Your Lordship, let me take Your Lordship to the prayer at page 32.
Your Lordship, I'm seeking only limited time only. I will
Till
get
conversion.
ready everything by.
Let them continue the engagement as part-time assistant professor in the computer science department in their respective colleges till conversion of their engagement to appointment on contract basis. That's a higher grade. Because as per the version of the petitioners, they are all eligible, even under the UGC and even under the
No,
AICTE norms.
had the post not been filled up, then the matter there would have been no difficulty in staying that order. But now two incumbents have already joined.
Yes.
They are not represented today also.
No notice has been served. They have chosen not to appear. Then what to do?
And what we have sought for is for the regularization, regular appointment as assistant professor, not as part-time assistant professor. So in the meantime, they were allowed to continue, and for the last more than 10 years, they were allowed to continue. They have served the state government with all their capabilities, and there's no such black mark or any complaint against them.
No, that's all right. But is there any vacancy now to accommodate them?
Two posts have been occupied by the respondents number 6 and 7.
6 and 7.
And other 2 posts have been occupied by 2 of the petitioners. 2 of the petitioners are also allowed to continue. And the other 3 are still remaining.
There are 7 petitioners.
7 petitioners.
4 and 5 are allowed to continue.
Yes, 0.5.
And rest were not allowed.
Rest not allowed. It's a very arbitrary decision of the state government. Let them continue as, part-time, because their service is required, and the fact that the service of the private respondents have been taken is because of dire necessity of the presence of teachers. Why should they engage those who are not eligible? If at all they are eligible, that's a different matter.
So,
Madam, then allow them to continue.
Your Lordship, if I may take your, my mail friend is finished, then I will make the argument.
No, he has completed
So far
his
as- so
argument
far
in
as
respect of
the-
the interim period.
Okay, I can make my submission then. Your Lordship, if I may take your Lordship kind attention to page number 64 of the petition.
Yes.
This is the advertisement one of 2015. Essential qualifications. Your Lordship, the type copy is in page number 66. Now, department in place of post, serial number 6 is PCA 1, scholarship, so and so. And essential qualifications, possession of net sets, sleds, etc., certificates, etc. Now, Your Lordship, due to the requirements and at that point of time, that is the decade ago, they do not find the qualified person. So they were recruited. They were recruited on casual by the state respondents, and Your Lordship, accordingly they were recruited. However, in the recruitment letter of engagement order also, which is in page number 68, Your Lordship, the relevant portion I would like to read is page 69. With your permission, Your Lordship, the selected persons of engagement of part-time professor should acquire net set within a period of 2 years, so and so. That is in 2015. Now we are in 2016, after 11 years. And Your Lordship, the next paragraph read, the engagement is purely temporary and may be terminated at any time without assigning any reason thereof. And Your Lordship, in the Annexure 14, in the Annexure 14, page number 74, for MCA assistant professor, the required qualification is BE, BTech, MCA with first class or equivalent in either BE, BTech or MCA with first class or equivalent for the 2 years. This aspect, like I have submitted to Your Lordship, has already been dealt with in the order dated 3/3/2026 in the first round of litigation. All these facts I have to put on record, Your Lordship. But if I may be granted, if 2 weeks cannot be granted, Your Lordship, I will file my affidavit at least within, because they have not challenged the 2015 order also, which is the principal order, wherein they were required to have the net set within a period of 2 years. But then on humanitarian ground, and it was their service was reassumed from year to year basis. But on a final notice, they were given a last chance for obtaining the required qualification. And while they were given a show cause notice, the respondent number 4 and 5 have attained their required qualification. That is why they were allowed to be continued.
They have obtained.
Yes, Your Lordship.
So therefore, they have been re-engaged.
Yes, re-engaged. In another fields also, not only the subject, because there are 2-3 writ petitions along in this kind of similarly situated but different department, Your Lordship. I can put all these facts so for ends of justice, Your Lordship. So if I may be given at least a week time, we can have the hearing in the interim order or the writ petition also. I'm ready, Your Lordship. But I need to put the facts straight before Your Lordship for ends of justice.
In that case, let it come up on Thursday, Your Lordship.
Thursday.
Your Lordship, not next Thursday, 24th.
That is the last working day. Friday is holiday.
Yes.
Friday I have engagement. Friday I have a personal commitment.
Friday is a holiday.
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 So let it be on Thursday.
Thursday, Your Lordship, Thursday I have some commitment, 25th. I will not be in the court. Wednesday, Thursday.
Then 29th of June.
Yes, 29th of June. Okay.
Let a copy of the affidavit be served to us prior to that.
Okay. Heard Mr. C. Lalaran Jawaba, learned senior counsel assisted by Mr. Learned counsel for the petitioner and madam for the state respondent. Number 1, 2
What order state respondents, Your Lordship?
for all the state respondents.
1 to 5.
1 to 5 and 8 have been represented.
Yes, 1 to 5 and 8.
1, 2, 5, and 8. Office note dated 17/6/2026 indicates that as per direction of this court dated 16/6/2026, the registry has tracked the consignment report, tracked the consignment and placed a report before this court, and as per said report, notice upon respondent number 6 and 7 have been delivered on 2/6/2026 and the 2/6/2026 respectively. No, on 2/6/2026. But they remain unrepresented today. The learned counsel for the petitioner has bribed for considering the interim pair of the petitioners. However, learned counsel for the respondent number 1, 2, 5, and 8 submits that she may be allowed to, no, she may be granted a week time to file the counter affidavit to bring on record all the facts of the present case. Accordingly, taking note of the submission of learned counsel for both the parties, it is provided that Grace shall raise the matter on 29th of June, and prior to that day, the learned counsel for the respondent number so and so shall file the counter affidavit and also furnish a copy of the same to the learned counsel for the petitioner in advance.
God bless.
This recording.
Give your pleasure.
Supplementary list, item 17.
May it please your lordship.
Yes.
Lordship, in this case, petitioner is behind the bar for 56 days, lordship. NDPS matter. Let the CD may be called for, lordship.
Okay. Hard miss, your name please?
Jamaico Simple, lordship. J Simple.
Learned counsel for the petitioner. This petition under section 483 of the BNSS 2023 is prepared by the applicant Sultan Ahmed Loskor, who has been languishing in jail hazard in connection with Cital PS case number 39 of 2026 under section 21C 25 of NDPS Act. NDPS Act. And also heard Madam additional APP, additional PP for the state respondent. So at what stage the case is pending? Is it surseated? No.
No, not lordship. No. Still at the investigation stage, lordship.
Okay. It is submitted that investigation of the case is still going on and surseat has not yet been filed, and as such, the scanned copy of the case diary may be called for. Accordingly, it is provided that the learned additional PP shall produce the scanned copy of the record on or before suggested date.
Lordship, Can it be on 3rd June, 3rd July, Lordship?
3rd July.
Yes, Lordship.
Yes, madam. Okay. 3rd July.
Item 18.
May it please your Lordship. Lordship, in this matter, petitioner is behind the bar for 150 days, Lordship. TCR may be called for, Lordship.
It is solicited case.
Yes, Lordship.
Charge sheet. Scan.
Heard Ms. So learned counsel for the petitioner, and also heard Madam. You have additional paper.
Additional paper.
Additional paper for the state respondent. This application under section 483 of the BNSS 2023 is prepared by the accused Dildar Hussain, who has been languishing in jail hazard in connection with Site 12 PS case number 9 of 2026 under section 21C/25/29 NDPS Act since 28/1/2026. The learned counsel for the petitioner submits that after completion of investigation, the IO has laid charge sheet in this matter, and now the case is pending before the learned trial court, and as such, scanned copy of the record may be called for. Accordingly, taking note of the submission of learned counsel for both the parties, it is provided that recessal call for the scanned copy of the record from the learned trial court, fixing the matter on when?
Lordship, 3rd July.
3rd of July. 3rd of July.
Mobilize.
Hearing list, item 13.
My lord, the brief of the case is that I'm a legal owner of Purity Pata number G738 of 1976. May you please take page 10?
Pardon?
Page 10 of my petition, may you please take it?
Page 10.
Yes, my lord. This is a copy of my Purity Pata. Then this Purity Pata was secured by the Ministry of Road Transport, which is arrayed as the respondent number 3. It is in page 19. My name is reflected in serial number 185.
Serial number?
185, page 19.
Page
19
19.
of my petition.
Serial number?
185.
185. Okay.
Since my land was secured by the Ministry of Road Transport and Highway, assessment was taken. And assessment sheet is in page 22 of my petition.
Page number?
22 of my petition.
22. Yes.
And my bank account number is also reflected herein. It is in the right column, second table, it is in the last column. Then the awarded amount is rupees 37 lakhs 17,672 along with the solicium. Then that amount was credited into my bank account, which is reflected in the assessment sheet. And the amount was credited on 14/2/2023. It is in page 28A of my petition.
Page 28.
A of my petition. This is type copy.
Yes. So this amount was credited in your account.
Yes, my lord. Then thereafter that the Kala The Kala, who is array as respondent number 4, has sent letter to SBI, who is array as the respondent number 1 and 2 in this hearing, to freeze my account. It is in page 33 of my petition, my lord.
33. Yes.
Then herein it is reflected like this. With reference to the subject cited above, I have the honor to request you to freeze transaction of State Bank of India account number so in respect of Pupilal Thamwanat Labung, as the account was mistakenly credited full amount of 37,17,672. The full compensation amount for acquisition for National Highway 302 project has to be apportioned between Pupilal Thamwana and Tourism Department as per the endorsed meeting minute. Due to this, my account was freezed by the SBI, who is array as the respondent number 1 and 2. Then if I go to the tourism department counter affidavit. Counter affidavit filed by the respondent number 5, my lord. Para number 4, my lord. Para number 4.
Yes.
Counter affidavit filed by the tourism department respondent number 5.
Yes.
May I read out, my lord? In reply to para 2 of the petition, the petitioner is not the rightful owner of the land cover under periodic pata. So he already sold his land cover under periodic pata to the respondent number 5 for construction of tourist destination for consideration of rupees 10 lakhs for development of tourist destination under central project. If then, my lord, you please take page. Then, my lord, you please take affidavit, counter affidavit filed by the respondent number 4. Oh, my lord, additional affidavit filed by the respondent number 4. Two affidavit was filed by the respondent number 4. One is the counter affidavit and another one is the additional affidavit.
Yes.
In additional affidavit, para number 6.
Yes.
May I read out, my lord? It is respectfully submitted that the Tourism Department Government of Mizoram had bought a portion of the land cover under periodic pata for a consideration amount of rupees 10 lakhs without formal sale deed as mandated. If there is no formal sale deed, how can they say that we have purchased? If they direct purchase, there should be a formal sale deed, which was registered under the Indian Registration Act. Then no sale deed was enclosed in their counter affidavit filed by the respondents. Then I would like to read out
No,
again
can they purchase the land without a sale deed?
No, my lord.
Okay.
In this respect, I'm relying in this case law.
Regarding validity of sale?
Yes, regarding the how to possess and occupy the private land.
How to?
Possess and occupy the private land. This is the report table judgment passed by the Supreme Court. It is my lord, there are 7 principles how to acquire the private land as per law.
Where it is stated?
It is stated in para number 19.
19. Yes.
Following are the 7 principles. Number 1 is right to notice. And number two, page 20 is right to be heard.
Page?
20, right to be heard. Page 21, the right to be a reasoned decision. Page 22, the right to acquire only for public purpose. Page 23, the right of restitution of or fair compensation. And page 24, the right to an efficient and expeditious process. And the last one is the right of conclusion. Then, my lord, after that, take page 28 of the judgment of the case law, para number 31.
Yes.
The 7 principles which we have discussed are integral to the authority of law enabling compulsory acquisition of private property. Union and state statutes have adopted this principle and incorporated them in different forms in the statutes provisioning compulsory acquisition of immovable property. The importance of these principles, independent of the statutory prescription, have been recognized by our constitutional court, and they have become part of our administrative law jurisprudence. If they want to occupy the
So according to you, these principles have not been followed by the tourism department
yes,
while purchasing your land.
yes, my lord, they are not following all these 7 principles when they occupy my land.
Okay.
Then the next one I would like to submit is that tourism department affidavit, para number 13.
Main affidavit. In the counter affidavit.
Yes, counter
Para
affidavit, my
number
lord.
13.
Page number 8.
Yes.
They reflected the extract of meeting minute, which was held on 17/11/2022. May I read out, my lord? The tourism department has established a structure on the property owned by Mr. P. Lathamwana. It is acknowledged by the tourism department that the establishment of the land lease of Pirdi Pata donated by Mr. Lathamwana lack of formal agreement. Donation cannot be complete without formal agreement. If there is lack of formal agreement, donation cannot be completed. Due to the absence of proper agreement, the matter cannot be resolved at the Kala level and must therefore be addressed in the civil court. The compensation from periodic pata so to be provided through the tourism department will include payment for the structure, fencing, RCC column, RCC tanki, and RCC pavement. The balance of the payment will be handed to the landowner, Mr. Peter Kamwana, given that this matter is between a private individual and the government, and affidavit is not required. This meeting will serve as the agreement in Remna. But I would like to submit that in this respect, the petitioner did not accept this meeting minute because they did not read out during the meeting time. Then all these are recorded as the record note of the Kala. Then the same can be seen at page 24 of the counter affidavit, in this counter affidavit. Page 24 of the counter affidavit filed by the Tourism Department, my lord.
Yes.
This meeting minute was reflected in para number 13. I would like to submit that there is no proper donation also. But they just occupy my land. They just occupy my land under fraudulent and deceive. Because before the construction of the tourist lodge, they promised me to award contract work. And also they promised me to employ one of my children in their department. But they did not fulfill their promise till today. But they are occupying my land. And my land, that periodic pata number G738 of 1976 was acquired by the Ministry of Road Transport under due process by issuing the required notification under National Highway Act. All the assessment was taken in my name. But as of today, they say that they claim that whatever the building construction should be, come to them. Then in my petition, my pleading is to defreeze my account only, to defreeze my SBI account only. Regarding the, then I would like to submit that regarding the occupation of my land, I am filing civil case before the court of district court, Lunglei.
What it says that suit is pending now?
Yes, it is still pending before the court of district court of senior judge, Lunglei. It is in my counter affidavit. It is in my rejoinder affidavit filed against the additional affidavit filed by the respondent number 4.
Yes. Paragraph number?
Annexure number 1, my lord. Page number 5. 5 is the civil court order.
Okay. Whether they have filed a written statement there?
Not yet, my lord. It is still pending.
Okay.
Then the,
Oh, who is representing the bank? You. So you have received a requisition from the other respondent for freezing the bank account.
Yes, ma'am. As per this honorable court order, it was already unfreeze.
Already
Unfreeze.
unfreezed.
Yes. As per the order dated 22nd March 2024.
Already unfreezed.
Yes, ma'am.
Yes.
then to dispose my petition.
Pardon?
To dispose my petition because it is already unfreeze. But the
Yes. Then your petition become infructuous
yes, my lord.
as per order of this court. Can you produce that order? In this present writ petition or in different?
it's present.
Here. So till now you have no instruction in respect of unfreezing your account.
No, my lord.
Then you obtain instruction from your client.
I already obtained my instruction, my lord.
Already obtained.
Yes.
So apart from this unfreezing your account, there is no other pair in this petition.
Yes, right, my lord.
If the account is already unfreezed, then this petition become infructuous.
Yes, my lord, right.
Yes.
Your Lordship, it looks kind of easy that way, but then all these aspects, it has already been dealt with. The problem was that they have approached this honorable court for unfreezing of the account. And the account was unfreezed by this court's order dated court's 22nd March 2024. But there was a condition. There was a condition that on the undertaking that they will revert it back, remit the amount on the basis of the case of this.
No, their only pair is to unfreeze the account, bank account,
Yes,
right?
yes, yes.
And
However,
except that we cannot adjudicate any other matter here.
yes, Your Lordship. However, Your Lordship, what happened was that at first tourism department were not impleaded. Tourism department is impleaded by my learned friend. I do not represent the tourism department in the matter. I represent only the Kala in this matter. So what happened was that the tourism department were not at first impleaded as a party. So they have filed an application as an intervener, and they were made a party. subsequently. And on making them a party, they have, this Honorable Court was pleased to unfreeze the amount, the account on an undertaking taken by, undertaken by my learned friend that if any adverse order is passed in these proceedings, the petitioner will be required to refund the amount as may be decided by the court, and the respondent number 4 will be entitled to recover the same by due process of law. So what happened was that it is the case of the tourism department that the land of the petitioner was
No, the question is, can we adjudicate that issue here in this petition?
yes, that is beyond their prayer.
here-
That is beyond their prayer. But for ends of justice, it was continued because the prayer was or any order for ends of justice.
No, this is her writ petition.
Yes. But then it will because agreed. They have allowed to be the land to be constructed on the verbal. Now, this is all these are admitted facts without any writings. Land is admittedly occupied by the tourism department and duly constructed the building which was completed and
No,
occupied in the year
tourism
2019.
department is run by the government.
Government, yes.
If the government do not know the laws and procedure in purchasing plot of land for construction of their tourist laws, what can be done?
And it is submitted by my learned friend that she
Whether
had
on
allowed.
or merely on admission, or we can
Your Lordship, I
adjudicate the
agree.
issue.
I completely agree that merely because having a sale deed or having the possession does not make the entitlement or legal title. It has to be registered under Section 17 of the
Yes.
yes, and then part performance Section 53A of the transfer of property that cannot be taken advantage. However, Your Lordship, the problem is that they have duly occupied. And in the year 2021, the notification came up, and then this idea came that they have to get all the compensation. Now, the Kala, while making the assessment before the award was passed, they have called the petitioner herein to the chamber. And in the meeting, the petitioner duly attended the meeting, wherein he have submitted that I think Your Lordship have already taken into the meeting minutes. The meeting minutes wherein he have considered that the compensation from P. Patel to be provided by the tourism department will include payment of the structure, fencing, RCC, column, etc. The remainder of the payment will be handed over to Pilal Thamwana. Given that this matter is between private individual and government and affidavit is not required, the meeting minutes will serve as an agreement in Remna. We quote in Remna as an agreement. And apportionment will be ordered issued accordingly. So it was duly, he attended the meeting and then duly accepted this. Now it is the case. They do not challenge this meeting minutes also, first hand. And now, in second thought, as an afterthought, my learned friend have submitted that it was not duly read out at the time of making the meeting. Now, admittedly, it was issued on 18th November 2022, and meeting was held on 17th November 2022. But then now they are stopped from saying that the tourism department are
No,
not
you
eligible.
tell me, can we adjudicate all those issues in this petition? Where pair is only for unfreezing the account.
Yes, I believe that, Your Lordship, for ends of justice we can, because even though the prayer may be limited, it says that or pass any order as may be required for ends of justice. So any other order. So ends of justice, because something transpires. But then my humble prayer, in my humble opinion, Your Lordship, since there is many clash of facts, this is a writ court. We cannot go into a facts which is in dispute. So I think the trial court is the best court to adjudicate the matter.
Yes, already one suit is filed before the,
That,
Eviction, yes.
yes, it's for eviction, not regarding the
Eviction of the
title.
tourism department.
Filed by tourism
In
department.
fact,
Yes,
Your
madam.
Lordship, this was heard before the coordinate bench
no,
of this honorable court.
we cannot deal with those issues in this petition.
So, Your Lordship, now, in my humble opinion, they are stopped from saying that they do not have any, so, but then the right approach would be the learned trial court, the lower court.
That can be decided in the civil court, not in this court.
Lordship, please, I am the main aggrieved party. So here, when they approach this
You are
for
for?
tourism department.
Yes.
So the one we have that the tourist lots, we are the one who constructed the tourist lots. My lord, initially they approached this honorable court with unclean hands, because that time, see the money that 37 lakh has to be apportioned between tourism department and them. So they should implead us. So without our presence, that interim order citing that we badly need for looking after the petitioner who later on passed away. So it was on condition, on undertaking, it was allowed to be withdrawn, the 37 by this order. So my lord, and after that, as my learned friend also stretched that, we filed impleadment, we are accordingly impleaded. So my lord, here the issue is that whether that DC, the Kala, had rightly passed that freezing order, whether it has to be apportioned between 37 between them and the tourism department.
No. First, you have to establish your right title and
Yes,
interest
my
over
lord, that I'll do
property.
that. I'll do that, my lord. Here the main prayer is the defreezing of the account.
Yes.
Defreezing the account. So my lord, whether freezings of the account was legal or not, that is
Yes.
important.
Yes.
So my lord, here from their pleading itself, that the freeze amount, the 37 lakhs, here that this honorable court noted in article that last order on 27.5, you kindly see 27.5. Justice Michael Zotankuma, he passed this order, frame one issue, 27 May 2025. Just very short order, only 2 pages. Allow me to read the lordship, please. 27.5.
Yes.
Heard Jacinta such and such, and the petitioner has prayed that she may be allowed to withdraw the writ petition, inasmuch as her SBI account, which has been frozen, has now been defreezed, and there is hardly any money left in the account of the petitioner. On the other hand, Learned Counsel for the respondent submits that the petitioner account has been defreezed on the basis of observation made in order dated 22/3/2024. Under such circumstances, this court is prima facie of the considered view that till the next date, the petitioner shall be allowed to operate the saving bank's account, subject, however, to furnishing an undertaking before the bank that in events any adverse order is passed in this proceeding, petitioner will be required to refund the amount as may be decided by the court. Respondent number 4 will also be entitled to recover the same by due process of law. Learned counsels for the respondent submitted the petitioner had also made a prayer for withdrawal of the writ petition on the earlier date, because after they received the money, they tried to withdraw. So that the case of the respondent is that tourism department had bought a portions of the land for petitioners for 10 lakhs. On the said land, the tourism department had built a tourist lodge, which had been completed in 2017. On the land bought from the petitioner, tourism department had constructed tourist lodge, which was a RCC building. The same had been completed in 2017. Tourist lodge was being run by the tourism department since 2017. The land of the petitioner and the land on which tourist lodge had been constructed was acquired by Ministry of Road, Tourism, Transport and Highway due to constructions of a road near tourist lodge. The tourist lodge building had also been assessed for payment of compensation. Respondent authority, while distributing the compensation amount, had mistakenly given the compensation for tourist lodge to the petitioner. The total compensation cost paid to the petitioner was 37,17,672, out of which tourism department claims that compensation for the cost of tourism building was 1857,836. Here, this is very important. The issue to be decided is whether the cost of tourist lodge building had been assessed by respondent authority and whether the said assessed amount was a part of 37 lakhs paid to the petitioner. In this regard, the respondent number 4 is directed to submit an additional affidavit stating as to whether any portions of 37 lakhs which had been deposited in the account of the petitioner included the assessment made for the tourist lodge constructed by Tourism Department. The affidavit should be filed within 2 weeks. Compliance to this order, because this order directed Kala to file whether the 37 lakhs has to be apportioned between Tourism Department and the petitioner. How this 37 lakhs assessment was made, it was directed to file this affidavit. And Kala filed their affidavit, Your Lordship. You kindly see Kala affidavit. Compliance to this order. Your Lordship, you are there? Relevant is from para number 4.
Yes.
From para number 4, it is respectfully submitted that at the times of estimation of acquisitions of land in which National Highway 302 in the stretch of land from KM such and such tanki, kalam, fencing and pavement was acquired from the land of Tourism Department, tourist lodge building at Labung. Assessment for tanki, column, fencing, pavement amounting to 7 lakhs with 100% solicium and interest which total to 14 lakhs 19,000. It is respectfully submitted that the crops, the maize was assessed from the land of P. Laltamona, the petitioner, amounting to 11 lakh 49,120 with 100% solicium, which total up to 2298,240. These 14 lakhs, this is the cost for the column, tanki and hill. Total of these 14 lakhs and 22 lakhs, it is 37 lakhs exactly. This is what the court directed to file to clarify this issue. Number 6, it is respectfully submitted that Tourism Department had brought a portion of the land of the petitioner covered under Pirik Pata for a consideration amount of 10 lakhs without formal sale deed as mandated. On the said land, RCC building, tourist lots, Labung was constructed by the department, which was completed in 2017. Partition and mutation of the lands both by the department was not completed in 2021, when notification for acquisitions was affected by National Highway 302 construction project was notified in 22/11/2021. This is para 7 is very important. It is respectfully submitted that due to above stated fact, on the strength of meeting that was held on 17 October in the office of Additional Deputy Commissioner Kala, as agreed by the petitioner who was a member of the said meeting, an estimate for land acquisition as well as Tourism Department was made in the name of the petitioner. Accordingly, compensation amount in respect of the said P. Pata 77 amounting 37 lakhs, that is assessment for Tourism Department, tanki, column, fencing, pavement amounting 14 lakhs. This is tourism share, and value of the crops, this is the petitioner share amounting to 22, was duly deposited and disbursed into the account of SBI belonging to the petitioner on 14/2/2023. If you Lordship kindly see this annexure, is very important. This annexure is how the 3G estimate that was made. Annexure 1. This is also enclosed by the petitioner.
The thing is that she has disputed selling of the land to the tourism department.
But that is not the issue, my lord. Here the issue is that whether freezing that amount, 37, has to be apportioned. It was freezing was rightly done or not. But that is issue in civil court. They already filed, it is pending before civil judge. That they file for this thing, setting aside of work order, why back in 2013? and also they pray
It is
for
not-
ejection,
That is not my prayer, my Lord.
ejection of the
That is
tourist
not
lodge.
my prayer. My prayer is to
Ejection of the-
ejection of the tourism
Also,
department
they
from my
file it-
landed property.
My lord, here my point is that if you
We are
kindly
not
see,
challenge-
if you kindly see their annexure, here very, very clearly how these 37 lakhs was assessed. Because admittedly,
No, you say, in this writ petition filed by her, can we adjudicate those issues?
no, my lord, I am not on that issue.
Then?
But the issue is that how these 37 lakhs came assessed. If you kindly see the annexure number 1, this is clearly written.
Maybe, unless you establish your right there, how can you argue on that point?
My lord, I have not, because it is admitted fact that that building, that column, the fencing, and another things which are going to be destroyed, already destroyed, it was 9 lakhs. It was already admitted fact. They did not deny also.
My lord.
Remaining crops, that is 19 lakhs, belong to them. The remaining, that if you, everything my lord, it is their petition. In fact, it is their annexure. They annexed this one. How assessment was made? Kindly see, my lord, that annexure. It is their annexure. See here, Pilal Khamwana, here, that is the crops, the building, it was written here, everything, and also tanki, column, fencing, from the tanki specifically 4 lakhs. Column and fencing, it is 3 lakhs. For pavement, it is 80 lakhs. Altogether, 7 lakhs. It is their annexure. And for them, there are many fruits. Thehai, mango, lychee, this one, that many other things. Here altogether, it is written very clearly, the total numbers of their compensation, the numbers of tree also is written, and it is here altogether 11,49,000. 11,49,000, it is 100% solicium.
No, you tell me, can on the basis of that annexure, this court can direct her to return the amount to you?
My lord, that my point is that the assessment made by Kala was made on the basis of this. This what is written here, the name of this is that 3G
No, that-
estimation.
That may help you in other proceeding, not in this proceeding.
Then my lord, that petition has to be dismissed. Because in as much as the freezing, that 37 lakhs was rightly apportioned, then there is nothing wrong done by the Kala and the bank also. Then it has to be dismissed their case since there is no violations of the fundamental rights. Because where is the violations of their fundamental right? They have not alleged any fundamental violation of fundamental rights. The money, if they say that it was
No, can you go and freeze the bank account of another person?
no, my lord, my simple prayer is that for the dismissal of the writ petition, in as much as there is no violations of the fundamental rights,
Why?
the department
Why and how?
the department had rightly done their part. Because on the basis of as per 3G estimation, as per their affidavit also, as per their annexure also, this apportionment 37 lakh was rightly done. There is nothing wrong. They have not alleged at all that it was wrongly done, it was wrongly assessed. If you kindly see their pleading, it was assessed, the whole land was assessed. But the fact is that some portion, that upon that periodic Pata 73, there is a standing building at the corner, the tourist lodge, and we spend a lot of money from that one, but only some portion, column, tanki, pavement, only that one demolished because of the extensions of the road. That for that portion, it was assessed, assessment was made. And the rest, another portion of land, there are some standing crops. That is 11 lakhs. Solicium is 100% under this national highway. Then there is nothing wrong done by the department, the Kala, for issuing that order. That's why there is no violations of any fundamental right. So that this writ petition is devoid of any merit. My lord, they have not disputed regarding that the column and the pavement, that assessment part.
My lord, all the assessment was taken in the name of the petitioner. Even the additional affidavit filed by the Kala, then whatever the apportion, whatever the rate which was determined by item by item, it was also reflected the petitioner name of the beneficiary. Then I would like to submit that the tourism department had occupied my land, but that occupation is illegal. Then it can be seen in the counter affidavit filed by the respondent number 5, page number 16. May I read out, my lord? In persons doing war letter number so I, along with Kelan and Kluanga surveyor, LR and S Nung Lewen for the demarcation of Labong Tourist Lodge new building area on 1/2/2022, we gather at the spot on 2/3/2022 at 10 a.m. and VC member along with Pulad Thamwan and his wife were also present. Pulad Thamwan stated that the amount of land like which he had received was for site development of the land and not from sale proceed of the land, and that he had not sold the land since the agreement stand unfulfilled. He did not agree to partition the tourist lodge area from his land, and he therefore did not allow the demarcation of the land in spite of pressing effort from the surveyor. That they did not purchase my land, and whatever they changed the purchase is also they submitted there is no formal sale deed. Then regarding the meeting minute, which was enclosed by the rejoinder by the counter affidavit filed by the respondent number 5, it is in page 24. Meeting minutes, second para. The tourism department has established a structure on the property owned by Mr. Pilal Samwana. It is acknowledged by the tourism department that the establishment of the land is for Piltik Pata donated by Mr. Pilal Samwana, lack of formal agreement. Then due to the absence of a proper agreement, the matter cannot be resolved at the Kala level and must therefore be addressed in the civil court. Then in second para, third para, the compensation from Piltik Pata to be provided to the tourism department will include payment for the structure, fencing, RCC column fencing, RCC tanki and RCC pavement. The remainder of the payment will be handed to the landowner, Mr. Pilal Samwana. Given that this matter is between a private individual and the government, an affidavit is not required. This meeting minute will serve as the agreement, and a apportionment order will be issued accordingly. Between the private and government also, if there is agreement, there should be agreement deed under register under Indian Registration Act, because this agreement, the third para is also regarding the immovable property. Whatever the immovable property, we execute agreement or sell deed, is to be registered under the Indian Registration Act.
Your Lordship, if I may make one submission, one suggestion, in fact.
Then my lord, according to my pleadings, let the matter be adjudicated, not beyond my pleadings.
Your Lordship, the prayer was to unfreeze the account, to show us as to why the account should not be unfreezed, and to pass any further order as may be directed by this honorable court. It is written in black and white. But I'm not going to say on that. Your Lordship, what I would like to suggest is that as soon as by order dated 3/3/2024, the account was unfreezed. And at that moment, they have withdrawn all the account, and then it was directed. My learned friend was directed to see how much in the account is left. It's only about 1,000 rupees. Now the tourism department will be greatly prejudiced, but because the condition was that if any adverse order is passed, then they will have to remit it back. So my only suggestion at this point is that, if this honorable court is of the opinion that we cannot adjudicate the matter beyond the prayer, the first prayer, that is the unfreezing of the account, but let the account so to be apportioned be deposited to the court or in the account itself, that cannot be, should not be taken out with the direction not to be taken out unless and until final decision is taken in the matter thereof, because otherwise the money is gone. So that is the main problem.
My
It can
lord,
be in RFA, etc. also, money is deposited. Yes, if the court have decided that the tourism department are not entitled, because there are many disputed, admittedly, many disputed facts. But the question is, admittedly, something has transpired, because how can a person let a building to be developed in a place?
No, you go and you avail the available remedy.
The apportion, according to the apportionment
Here,
assessment.
this court cannot adjudicate the disputed facts.
Yes, but
Maybe,
then money can be directed to be deposited.
There
Your
may be
Lordship.
some admission here or there, but only on those admission, this court cannot adjudicate the disputed question
Your
of
Lordship,
facts.
money can be deposited to their, it can be deposited back to their account, but not to be touched. Or it can be deposited into the court. So that way, matter can be disposed, Your Lordship, without prejudicing any rights of the respondents as well as the petitioners.
No, whether we can issue such direction, because
Yes, of
it is
course.
her bank account,
Your
he
Lordship,
can
Your
operate
Lordship,
it or
our
she may
prayer
not
was
operate it.
prayer portion.
It is her prerogative.
Our prayer is not only to unfreeze the account. It says that and pass any further order as may deem fit and proper. That is included. So for ends of justice, as I have pointed out clearly, that it will prejudice the tourism department. It will, the suggestion that I have made, Your Lordship, if taken into consideration, it will not prejudice them. It will not prejudice the tourism department either.
No, if the amount lying in the account has already been withdrawn, then
Yes, it is already withdrawn, but then on the condition that it was unfreezed, but then there was a condition. The condition was there. So in line of that. That was why this honorable court have requested us to make an additional affidavit so as to make sure, as to ascertain the sum which is allegedly claimed by the tourism department.
Lordship, whatever they submitted, they did not have any evidence
They do not
to show
have either.
because
They do not have either. My
because
mother
they
friend
say
have
that
submitted
because they
the
said
my
that
mother friend
we
have submitted
purchased
that she have-
the petitioner land, but there is no proper formal
okay,
certificate.
we will list the matter in the next week for further consideration. Heard Ms. So learned counsel for the petitioner, and Madam for the Kala, and Mr.
Jessica Lusano for responding tourism department.
for the respondent number 4. Respondent number 4, you for bank. 1 and 2, and Madam for respondent number 3. Heard in part, list the matter on Tuesday.
Matters pertaining to the Itanagar bench. Item number 1.
Yes, Mr. T. Son, you have filed your affidavit.
My lord,
What is your stand?
my lord, my stand is that by this affidavit, the measuring land measuring 68.40 hectares occupied by the 9 petitioners who are the land affected people in Dambuk area for the construction of Divang multi-purpose project, my lord. So this is the, my lord, latest one, my lord.
No,
48.
Mr. Son, you see, you are claiming your right over the 17.62 hectares of land also.
My lord, that has been, my lord, earlier order. It was also passed by this honorable court, my lord,
to some other parties, that is 17 point. No, my lord, I would like to take your lordship the order.
So you come to the paragraph number 5 of your affidavit.
My lord, 5 is that now the petitioner claim 17.62 hectares and 66.40 hectares to be intake. So, my lord, I forgot this one 17.62, my lord, as per the
No, that's
direction
all
of
right,
the
but
my.
you ought to have indicated this in your affidavit. Then we could have disposed of this petition today.
My lord, that can be recorded. My lord, my submission kindly be recorded, my lord.
No, Mr. Son, on your verbal
My lord.
submission, this court will not pass any order.
My lord, there will be overlapping, my lord. Earlier also, my lord, this honorable court was pleased to pass an order directing the other parties. That is, my lord, 17 point something, my lord, hectares in 17.62 hectares. By the order, my lord, 27/4,
No, that's all right.
2026, my lord.
Objecting that you have filed a review petition here. The direction for filing the additional filing the affidavit was to make clear your stand.
My lord.
But you have again claim your stake over the 17.62 hectares of land.
This my
If
lord,
you
I would
are
like to.
if you are intending to forgo your claim over the said stretch of land, you file an
My
additional
lord.
affidavit. Then I will pass the order. Yes, Mr. Tara.
Yes, my lord, before Mr. Tara address, my lord, may I just point out one thing, my lord? My lord, whole thing starts, my lord, after getting approval from the government, my lord. Assessment made by the, my lord, assessing authority that was provided by the district collector. If your lordship Feroz, my lord, 303, my lord. This is the power of attorney, my lord, done by the review petitioner. Interestingly, my lord, this is dated 28/3/2026. At my lord, the final approval was conveyed somewhere in 2025, my lord. But the interesting factor is this, my lord. 305, I don't know your lordship have or not. My lord, the scheduled land, my lord, is totally different, not at all connected to 17.6, my lord. This is different land, my lord. Not at all connected to 17.62, my lord. This is totally different. If your lordship see the notification of my lord 17.2, my lord, boundary discussion is different, and here that scheduled land is totally different, my lord. Perhaps that could be the reason, my lord. Mr. Soni is saying, my lord, he is no more, my lord, pursuing my lord 17.62, my lord. Maybe this could be the reason, my lord.
Maybe. Now let Mr. Son file an affidavit, additional affidavit, that he has no claim over the 17.62 hectares of land.
17.62, like.
Yes, my lord.
You file it on Monday?
Yes, my lord.
Then I will take up the matter on that day at 2 p.m. and we will pass the order.
Yes. My lord.
Right?
Yes, my lord.
Any objection, Mr. Gaurav?
No, lordship,
That will be fine, Lordship. But before you, after filing of the affidavit, Lordship, if this matter may be fixed for just 5 minutes to hear us, Lordship, because this compensation amount 17.62 hectare was pending for such a long time, despite being a legitimate order,
Okay,
Lordship.
we'll dispose it of on Monday. Let him
Okay.
file additional affidavit.
Okay.
Well,
No, Lordship, yes. Lordship.
That's fine, my lord.
Lordship.
Okay. Heard Mr. T. Son, learned counsel for the petitioner. And Mr. R.S. Nabam, learned additional advocate general for the state of Arunachal
my lord,
Pradesh.
I am 4 to 8, my lord. I'm sorry.
1 to 8. Mr. T. Gorom for respondent number.
4 to 8, my lord. To 4 to 8. 1
And
to 8.
Mr. Tara for respondent number.
11 and 12, I am assisted by A. Lingi, my lord.
Okay. 11 and 12 assisted by Mr. Learned Senior Counsel, assisted by Mr. T. Gorom.
Not allowed.
A lingi.
Okay.
A
Learned
lingi.
Counsel. After hearing learned
And for
counsel
the-
for both the parties,
Yes.
it is provided that Mr. T. Son, learned counsel for the petitioner, shall file an additional affidavit indicating therein that he has no claim over the stretch of land measuring 17.62 hectares of land. Recess and list the matter at 2 p.m. on Monday.
Lordship, we are grateful.
On that day, an endeavor will be made to finally hear and dispose of this petition.
My lord.
Deeply obliged, Lordship.